Good afternoon. We are filming this on May 4th, 2021. My name is JP Brown. I'm a civil litigator here in Richmond, Virginia, and I'm also the Young Lawyers Division Chair of the local chapter of the Federal Bar Association. And today it's my honor to have a conversation with Judge Elizabeth Haynes, specifically to discuss practice tips that the judge has for young practitioners in federal court, and also for law students who may be interested in pursuing a career in federal practice. And so, Judge, on behalf of the Federal Bar Association and the University of Richmond's School of Law, thank you very much for giving us some of your time. I know you're very busy.
Thank you. It's my pleasure.
It probably makes the most sense, at least particularly for the law student audience who may not be familiar with the role of the federal magistrate, to start off with just, describing what your role is, what type of cases you hear, and what your day-to-day life is like in the Richmond Federal Courthouse.
Sure. The first thing I would tell most law students is that federal magistrate judges are used differently throughout the country. And so what I say about my practice in Richmond may be very different if, for example, you apply for a clerkship in a different part of the country. So just keep that in mind, that what they do may differ significantly. But for me, I like to break down my duties into about 3 different categories. The first is any preliminary criminal matter. So anytime an individual is arrested and charged with a federal crime, the first person that they see, first judge they see, will be me, which means that I'll conduct their initial appearance, their detention, which is like a bond hearing, or any other preliminary hearings. And then I also handle any type of preliminary criminal investigative matters. So for example, search warrants, or criminal complaints that need the signature or the finding by the magistrate judge of probable cause. I'll handle those not in court, but on the back end with the prosecutors. So that's about 1/3 of my duties, and that involves a lot of in-court time, hearing different types of matters. The next 1/3 are any case any civil case that's filed in the Richmond division typically will be referred for settlement. And so in that context, the magistrate judge serves as a mediator for the case. And so that's very different from my other jobs, because in that context, I'm meeting with the parties. Most of those communications are ex parte. I'm talking to them one-on-one, and we're trying to figure out if we can resolve the case through mediation. And then the last 1/3 is sort of a catch-all. So I handle Social Security appeals. So if for individuals who have applied for Social Security disability benefits, if they're not happy with the outcome in the administrative process, they have a right to appeal. And I would review and handle those appeals and write reports and recommendations for the district court judges. I also manage kind of preliminary matters for any case that's filed by a prisoner, and also the misdemeanor docket, which means that, if you are on an Army base in the Eastern District of Virginia and you speed or get a DUI, you'll come here to court and I'll handle your matter. And then finally, I also preside over our drug court, which is a reentry court. So for individuals who are on essentially federal probation, who have been admitted into a more intensive treatment program, I preside over that program. And the idea there is to provide them intensive treatment, supervision, in order to help them with substance abuse issues. So I think I got everything, but that's the gamut of what I do.
You sound very, very, very busy. In terms of all of the duties that you just listed, would you say it's a pretty even split 50-50 between the criminal side of the law and the civil side of the law, or is one weighted more heavily in terms of your day-to-day work?
I would say it's fairly even. Those other tasks like the drug court and the prisoner docket and Social Security, those I don't really consider them civil or criminal. They sort of fall into their own category, but roughly the civil and criminal is fairly even.
Okay. For the law students, when a case is normally filed, it first goes to the district judge, and then the district judge will refer it to you?
For settlement purposes. And then I should have also mentioned, I can also hear civil cases by consent. So if the parties agree to the jurisdiction of the magistrate judge, then I act as if I'm a district court judge for those civil cases.
And then when something comes into the magistrate's chambers for settlement, how does that process then play out in terms of the prep work and then the leading up into the conference?
Sure. So typically, my clerks will ask the parties if there is a particular couple of weeks that they feel settlement or a settlement conference would be particularly helpful. And so in some cases, a very early settlement conference may be best because there might be, a limited amount in dispute and you don't want to spend a lot of money in discovery before you have your settlement conference. In other cases, there may be, a factual matter that's really in dispute, which drives the party's position. And in that case, some discovery might be especially helpful. So we'll typically ask the parties, when are you trying to set this settlement conference? And if we can accommodate that, and after I look at the case, I think that what they're asking for is reasonable, we'll generally set the settlement conference on a date that works for everyone. And then the parties, I enter a scheduling order, which kind of sets forth the process, which generally requires that the parties submit a settlement memo to the court several days in advance so that my law clerks have a chance to look at it and I have a chance to look at it. And then the settlement conference is held about a week and a half later. It has, since COVID, almost all of those settlement conferences have been via Zoom. There will be a point, I think, that we transition back to in-person settlement conferences, but certainly over the past 9, 10 months, 12 months, they've been via Zoom.
I believe I read somewhere, and I'm not sure if this is a direct quote from you, but you said that settlement conferences are a problem-solving endeavor and not just a chance for attorneys to advocate for their clients. How hard is that first off, do you, from what you are able to see, do most attorneys agree with that, or people really trying to litigate the case in front of you?
I see both. I mean, there are some attorneys, people are different, attorneys are different, and everyone's going to approach a settlement conference in a different way. But certainly, I always say to people, and before I come into a settlement conference, I've read the memos, I've read anything else filed in the case, especially, for example, if the district court has ruled, on a motion to dismiss and has already set forth some findings in the case, I'm obviously going to read that. And then it's especially helpful, for example, if the parties attach certain documents or key evidence that really assists in understanding the case. But I'm going to turn back to your question. I always say to people, I'm not your fact finder. I'm not your jury, and I'm not the judge who will be deciding your case. And you don't have to convince me. I used to say to my clients fairly often, I don't know what happened. I wasn't there. And I'm not going to be able to tell you whether, you did what they said you did or you didn't, because I wasn't there. And I say that a fair amount in settlement conferences because I need to understand your strengths and your weaknesses, but I also need to understand your priorities. And it is helpful to some degree, especially if it's a complex legal area. If I don't understand something or if it turns on a particular, a subsection of a subsection that the attorney's like, let me explain, there's something funny here that you need to understand. And certainly that's helpful. What I find less helpful is, let me give you my opening argument or argue my motion in summary judgment, because, I think all attorneys recognize that you might, for example, raise certain arguments in a summary judgment motion, but which ones are your strongest. And I probably know which ones are your strongest too. And so it's more helpful if we can just really focus on what the nub of the case is, rather than kind of, arguing every point. I like to start with the attorneys in every settlement conference. And many of them take that opportunity to sort of flag issues for me that they may not want to flag in front of their client. And so I find that especially helpful as well.
So is it accurate to say that the quicker that, a practitioner can get the court, can focus you on the narrow issue, that's going to be most at play in the case, that's probably the most effective use of their time and yours. Is that fair to say?
I think it can be. I mean, sometimes, and the only reason I hesitate is because there are plenty of cases, maybe even the majority of cases, in which the legal issues are not what is driving the case. Mm-hmm. And so it's, and I'll give you just kind of an example that comes to mind. So, let's talk about if medical expenses. And so if, for example, a plaintiff brings suit and they know that they have liens or have to repay in some way, let's call it $50,000. And defendants are like, I'm only going to pay $50,000. Well, the problem there is it's unlikely for a plaintiff to accept a settlement where they walk away with nothing or ultimately owe their attorneys money. And that has very likely nothing to do with the merits of the case, but can absolutely drive what happens in the settlement conference. And so it's not always, oftentimes those issues are really what I need to understand, which might not be apparent from what's submitted initially.
Okay. You mentioned briefly preparation. And I think as lawyers, we always have a tendency, and for good reason, to focus on our own preparation, making sure that we understand the facts and the legal issues that are at play. How important, when people are coming into a settlement conference with you, is it that they prepare their client for that process? And what are the ways that you would recommend or that you think are effective in terms of prepping the client to be a member of the conference?
Sure. I think it may depend on who your client is. And so if you have a client that is new to a court case, has never appeared in court before, doesn't, is just your average guy or girl off the street, that preparation is going to be different than, someone from a corporation who's been to several of these. In the latter category, I think the preparation is just explaining to them these federal mediations, with, at least in our court with the magistrate judge, have differences from private mediation. They're shorter. We have less time. We're trying to get the case settled. And there's probably a bit more pressure applied to the parties than in private mediation. And so for your corporate clients, you might want to, explain how this process is going to be different from a private mediation. And then for individuals who haven't appeared in court before, it's a lot of times they're very nervous, and we try to keep it. I mean, it is a court hearing and there is some formality to it, but certainly I want your client to feel comfortable enough that they're going to freely speak with me, because otherwise, you run the risk of missing a lot of information. And so, I think explaining kind of the goals of mediation, why we'd want to do it, it's going to save you money, it's going to save you time. I always say to people, you have control at this stage of the case. Once your case is submitted to the judge or the jury, you lose control. And so even though, in order to get this case settled, my goal is to make both of you unhappy, but willing to accept this agreement. And so I think trying to introduce your client to those types of ideas is helpful to me as well.
You talked about moving on from the settlement conferences. You talked about you also, as magistrate judge, have the ability to hear civil matters and trials so long as the parties submit to your court's jurisdiction. What are the benefits to the parties in terms of doing that? And do you find that's something that is overutilized or underutilized?
Sure. So the benefits would be, I think naturally, the magistrate judges would have less civil cases on consent than your district court judges would have original jurisdiction. So the idea being, if you have an especially complex case or you anticipate discovery issues, or you're going to need a judge to look at certain matters in your case, and have extra time to do that, I think the general thought is your magistrate judges might have that availability more so than the district court judges. And so that would be one reason. I'll tell you, so since I took the bench, which was about a year ago, for most of that time, I've been the only magistrate sitting in Richmond. And so because I'm handling the magistrate duties, I've had a very small handful of consent cases. And so that we've done that for purposes of controlling the docket. But so that, that informs my answer. But was there a second part of your question?
Just what you think really the benefits of the magistrate jurisdiction are, as opposed to waiting for the case to be heard by the district court.
Yeah. And I mean, I think, you're also helping the court in that it allows us to hear more cases and adjudicate them more quickly. And so I think that's generally why courts, say, hey, here's your consent form if you're willing, that it's a benefit to the court. But I think it's also a benefit to the parties as well.
You had mentioned that you took the bench a year ago. You were sworn in back in June, I believe. What was it like for you to take the bench in the middle of a pandemic?
Well, it was a bit different. The court had been closed up until about the Wednesday or Thursday before I was sworn in, and then I started immediately. So with COVID, the court really did a good job of trying to respond to where the science was, and so we made changes throughout. And so it was really for me, it was a moving target throughout that entire process, because even though the court reopened, there was a period of time where, for example, they didn't have jury trials and there was no grand jury. But then we had to figure out, how do you resume those things safely? How, for example, one change that was made is typically we would do our initial appearances for criminal defendants in person, and throughout the district, those were transitioned to remote hearings so that you're minimizing the number of people coming into court. And so, that to me, it was just very interesting to see the court respond to, the shift in the science and the numbers and where things were, to ensure that the court could still function. And it did, absolutely. And across the board, matters could be heard and handled and adjudicated. So we're starting to kind of come out of that. And so I think it'll be interesting to see what changes and what doesn't change, and how, the court further adapts going forward.
If you had to hazard a guess, do you think, given that we have all had to figure out virtual practice, practicing via Zoom, just like we're having our conversation right now, do you have any guess as to how much of that is going to stay, or do you think we're going to go mostly back to in-person hearings the way we did pre-COVID?
I guess I'd say, first, I think it will be very much directed by each judge. And so I think down the road, it would be likely that the instruction is, to the extent that you're willing and able and it makes sense in a particular case, then handle those matters remotely. I did recently see a party in a civil case request that their experts provide testimony, remotely, and that request was granted. I don't know whether that request would have been granted 2 years ago. And so I think certainly the benefit of this pandemic will be that everyone was forced to adapt and to use technology in different ways, including the courts. And understanding the availability and the limitations of the technology will mean that at least it's available in the future. But I think you'll see that, it'll be decided likely on an individual case-by-case basis.
Are there any challenges that you might have that I would say that lawyers may not appreciate that judges have in dealing with things virtually? And are there ways that lawyers could better anticipate or do things better to alleviate some of the challenges that judges have with virtual practice?
Yeah, there are. I mean, the first challenge for me is that because it's remote, it's on a computer screen, you don't have those same, the trappings of the courtroom that sort of impress upon people the importance of a hearing. And things such as, when somebody takes the stand, I say, okay, you're going to now take the stand. There's no stand. They just start talking from their little box. And so, you have to adjust to that, and also to ensure that your record is, that you can still create a record. The challenge, I think, and what I see some litigants and parties doing is because it's on a computer, it feels less formal. And so you see that, you see people whose family members will come up and talk to them behind the screen, or they get distracted, they're working on other things. And so I think that's a challenge, obviously, and also problems with, being able to hear people, the bandwidth, there's a problem with their connection, and making sure people understand that and know how to address it. Specific challenges that I have and things that I would tell attorneys and parties is, I find it fairly helpful when individuals, especially even in your name, identify yourself. And so a lot of times people will have, I don't know if it's their like email name or something, but it's not their full name. And so you don't always, sometimes it's very unclear who's in each box. And so I always say to people that's the reason I put mine Judge Haynes. It's not because I want to remind everyone I'm a judge, but because I think it helps when there's someone who's observing court or a witness, that they are clear who is actually the judge, because you're not sitting up there on a bench and you don't know that. And so I try to make it clear to the people participating that I'm a judge, and I do that, through my name. The other thing is, in settlement conferences, a lot of times attorneys will join with their clients in one room, or, they'll be in their conference room and they'll use, whatever technology that the firm has, which is showing a fairly small picture of each person who's participating. And the challenge for me in that is that I can't see everyone because they're very small on my screen. And so, I get a lot of my information when people make faces, when we talk about things, or the clients make faces, and you can tell a lot when you can actually see someone closely. And so when they're smaller, that's kind of a tool that's taken out of my tool belt. And similarly, I talked to you about the fact that sometimes I'll go and I'll talk with the attorneys, and the attorneys will, say things that are very helpful, like, hey, let me tell you, we're going to argue this, but I'm telling you we're arguing that because that's what my client thinks, but I know that's not going anywhere, Judge, and I really think the issue here is X. And they wouldn't say that in front of their client, which I understand, and I'm not, but if I have you in the same room, again, that's just a tool that you've taken out of my tool chest, and I don't get to use it. And so I always say, just think about kind of those things as well. And so you have some challenge. There are definitely some challenges. There's also some benefits. So, somebody's in California, they can join a settlement conference tomorrow. Obviously that couldn't happen if they had to fly out. So there's both benefits and drawbacks to it, definitely.
Yeah, I would agree. I recently argued a summary judgment motion in the Western District of Virginia, and the supervising attorney that I was working with really wanted me to make a stronger argument in a particular point, and we just recognized afterwards that, they could have, back in pre-COVID times, he could have just slid me a note at counsel's table to, to clean up a couple of points. And it's just, there's just some challenges that are inherent to this whole process. So obviously you weren't, born a judge. You had a legal career before you took the bench. What was your first job coming out of law school?
Well, my first job is I was a law clerk for Judge Goodwin, who's a district court judge in the Southern District of West Virginia. After that, then immediately following that clerkship, I clerked for Judge King on the Fourth Circuit Court of Appeals.
Okay. What was it that made you want to pursue a clerkship, and why would you recommend, if you would recommend, clerking to law students? I absolutely recommend it. I just think the experience for me was invaluable. And I think for most people, it's invaluable. The reason I decided to pursue a clerkship, I actually have to credit University of Richmond in, their promotion of clerkships and their assistance. When I was a third year at University of Richmond, I had an externship with Judge Hudson in the Richmond division. And so, I saw from that experience just the value in clerking, and that encouraged me to ultimately apply. And then I always have to give credit to now Dean Spencer at William & Mary, because I was a bit uncertain as to whether I should do 2 clerkships. And I went and talked with him, and I started to say, I'm not really sure if what do you think? And he just said, stop talking. If you have the opportunity to clerk on the Fourth Circuit, I don't know why we're having this conversation, and you should take it. And I don't know why we were having the conversation either. It was, clerking has been one of the highlights of my career, and I would just recommend it strongly to anyone who's thinking about it. Were there any particular words of wisdom or lessons that, your judges impressed upon you that have stuck with you over the course of the career?
Sure. One thing I remember that Judge Goodwin talked about, he had been in private practice for large periods of time, although he'd also served as a U.S. attorney. He talked about case selection and, thinking about your ability to effectively advocate for your clients. And what he talked about was, if someone who's been harmed, for example, but may not have a claim, or who the type of claim they need to bring is not in your area of expertise, that all of those things you really should be thinking about when trying to decide whether or not to take a case. And I didn't, I'll tell you, I did not really appreciate that advice until I got into private practice, because trying to figure out which cases you should take, it's tough, it's difficult. And, you have that experience where you have an especially challenging case for a number of different reasons. And then you realize once it's taken you, 3 or 4 times the time that it took another case that, that maybe you really want to, how you think about that, you learn about case selection and taking which cases to take. And so I really appreciated his advice, but it wasn't until, a good 10 years later that I really understood the advice that he was giving me.
For the law students who will be watching this, is there a particular quality that you find most valuable in a law clerk, or what are the things that they should do to prepare themselves if, for example, they wanted to clerk for a magistrate judge in the Richmond division?
One thing that to me I find most helpful, and I think this is true actually in any job, so it's not particular to clerking for me, but the ability to predict what your supervisors need is so helpful. And so, what I mean by that is, for example, that there's a motion coming up that your judge is going to hear, and maybe it's different. And so, to think in advance, like what let me read everything. Let me figure out, what is my boss going to need for this? And when do I think they're going to need it, and do it in advance? Or even if you think you have to go and say to them, you have this hearing next week, and I think you're going to need these things. I'm going to go ahead and get them ready for you. And so just that ability to not just be the person who takes work from your supervisor and says, okay, I want you to do these 10 things. Okay. But to actually anticipate and plan ahead and help them through that process. To me, that's the greatest skill a person can have, and it's the most helpful. And it's something that, they certainly don't teach in any school. And so that's usually why I mention it.
After you clerked, you went to work for the public defender's office. What drew you to that kind of work?
I always, when I talk to people about how they ended up in their particular practice or doing their particular work, many times what people say to me is, well, I really thought I wanted to do X work, but then this one partner came in and I started working on some random project. And next thing I knew, I was the subject matter expert in my firm for that. And now I have my entire practice is focused on that area of the law. And I would say that is generally how my career came about. My background, I had worked before going to law school in corporate finance. And then I was an AmeriCorps or Vista volunteer for a nonprofit. And so when I started law school, I really thought, because I have that experience, I really, maybe I should go into corporate law or some sort of transactional practice because I had that experience. But when I was doing my clerkships, that is when the economy fell out and the market dropped, and there were the jobs where I thought that I was going to have, they were not there anymore. And so I was offered or applied for a position with the Federal Public Defender's Office, but it was a 12-week temporary position covering for someone who was out on leave. And so I took that job, in part because I knew of the reputation of the Federal Public Defender's Office, but also because, you were truly practicing law in that position. And I thought it would be a great experience, but it was sort of very much happenstance that I ended up there and not somewhere else, and was driven in large part based on the economy. So, but once obviously I was there for 7 years, so I enjoyed it thoroughly, and I was very lucky to have fallen into the position.
What is it that you think, in your opinion, makes an effective defense attorney or an effective advocate in general?
Sure. As a defense attorney, I think what I found to be most effective was you are essentially the primary person who's there to advocate for your client. Oftentimes, criminal defendants and their families don't understand the process, don't understand exactly what's happening and why, but also feel like they don't have a voice and no one to advocate on their behalf. And so filling that role, which to me is really twofold. One is the communication of the process. This is why we're having this hearing. This is what it's about. This is the standard. This is why we're going to argue the things we're going to argue. Is there anything else you think we should argue? That piece of it is as important as what happens in court. And then separately in court, you're the advocate for that criminal defendant, and they need to feel like they were heard throughout that hearing. And that can be, a delicate dance sometimes, because, they may want you to make an argument that that the court's not going to, may not respond to. And so you have to figure out a way to make that argument, but do so in a way that's going to be it's not going to shut the court down when they're considering your argument. And so that's a balance.
And what was it, because you've worked on the criminal side of the law and the civil side of the law, what was it that drove you to make that career transition?
Mm-hmm. I mean, I'll say that my experience with the Federal Public Defender's Office was, all around absolutely positive. And I can say that, for law students especially, to me, one of the great benefits was, I was in court week one, and I was trying a criminal jury trial in my first year. And I tried numerous criminal jury trials, and I had mentors. I always tell the story of how I would get a case file and I would walk around the office and knock on every single attorney's door and say, hey, you got a second? And I would talk about each case and what I should be doing and how I should be approaching it, and was I missing anything, and what would be their approach. And so having that support and the experience was just invaluable, as to learn to be an attorney. And I just absolutely credit that office with both their training, but also just giving me that opportunity. But I will say that is a very emotionally challenging job, because you are dealing with people who are most likely at one of the lowest points in their lives. It is often the lowest point in their families' lives. Sometimes it's resulting in the separation of parents from their children. And so, to deal with that every single day, it was very challenging. And while I remained a CJA attorney after I went into civil practice, because I enjoy the work, but I wanted to diversify both my practice so that I would have the experience to do not just criminal work, but also civil work. And so that's really what kind of prompted me to make the change.
You just mentioned the CJA program. For people who predominantly practice in state court who may be interested in getting into federal practice, what is that? What is that program?
Sure. So there's a CJA, it's a court-appointed list. So, and I would say, if you already have a criminal practice in state court, you probably know about the CJA list, but for individuals, criminal defendants, where a conflict exists with the federal public defender's office, the clerk's office and the court has the ability to appoint an attorney from the CJA list. And so that's a court-appointed list. And so you're being paid directly by the court, and you're taking criminal appointments. We do have both a misdemeanor list and a felony list. And so if you wanted to get, if you had, for example, less criminal experience, but you wanted to develop a criminal practice, you might want to start on the misdemeanor list so that you could just generally get experience in federal court with a criminal case. And then later, work on the felony list. But separately, and I think what may also interest other members, is that we do also have the pro bono mediation project. And so for civil practitioners who want to also get in court, and I'll say, look, these are a benefit to both the community and the court, both programs. And they also benefit, I think, the attorneys in the sense of this allows you to get in court and to assist the bench with representation of individuals who can't afford it. But also on the civil side, allows younger attorneys to, for example, lead on a civil mediation. And so I actually probably should just step back to the civil mediation project. In those cases, typically you have a pro se litigant, and they have litigated the case, to mediation essentially. And we have the ability to appoint an attorney for just mediation purposes. And so, that is purely pro bono. There's no compensation that comes from the court. And then the purpose is to simply represent the individual as the pro se individual through the mediation process. But if the case does not settle, then the representation ends. And so I participated in this program as an attorney at least 2 or 3 times when I was an attorney. And I think it is really a help for the process, both the pro se litigants as well as the other party, to have another attorney there just to help them through the process. And we've had fairly good success with the program.
Since you're talking about community involvement, I'd like to spend, if I can, what's left of our time discussing ways that you think are beneficial for young lawyers or, in fact, law students to get involved in the community.
Sure. I mean, what I'd say is what I found for myself is, pick at least one or two, but probably not more than that, bar associations or legal organizations that you want to be involved in and becoming deeply involved, right? And so that's what I mean by that is rather than joining 4 or 5 bar associations and only going to the one annual party each year, I would recommend joining fewer organizations, but becoming more involved in each. And I think the benefit of that is that you'll meet more people, you'll establish relationships with them, and ultimately you'll get more out of it. But then separate from like the bar associations and things like that, because there are a ton of nonprofits and small organizations that could really benefit from the assistance of having an attorney volunteer on their board. And so I wouldn't limit yourself to purely legal organizations. I would find other organizations that do the things that you're interested in and volunteer in that way. And then the other thing I would mention is obviously the state bar, for example, the Wills program that, it just allows you to learn about another area of the law and to volunteer in a fairly kind of narrow way that allows you to volunteer in a way that makes sense for you when it's convenient to you. And so I think there's just a ton of programs out there that allow attorneys to volunteer. And I think that's a great benefit to your development, but also just to the community in general.
If I can, I just wanted to, as we wrap this up, I just wanted to, turn it over to you if there's any sort of advice or if there's any recommendations that you'd like to pass on to, the law students and the young practitioners that are watching this.
Sure. I think, if I was giving some advice, I would say, your professors and deans, but also the alumni of your school, use them as a resource, and I think, I look back now and I think about the professors and the classes that I took. And I did build relationships with those professors and my deans, but I certainly think, I left a lot on the table. And I would just encourage you that, those individuals have such a deep knowledge of the area of the law, but also, people in that area of the law and law firms in Richmond or different places you could work in Richmond. And they are there teaching because, they have a commitment to the students' development. And I know that they would all be committed to spending their time to assist students. And I think, what happens is students don't focus on that sometimes. And I would just encourage you to really spend the time working on your relationships at the law school. And then also, I always say to people pretty much every time I talk, like, look, if you have questions, you feel free to call people. I mean, whether that's someone in private practice or a judge, or, if you want to have an informational interview, I think people are really hesitant or feel like, oh, I'm going to be a burden on those people. But especially if they're an alum of your school, I think most lawyers are absolutely willing to share the information that they have. I always say, don't expect a job, right? Like the point is not to get a job, but the point is to get information and to build your network. And as students, I know it can be really hard to do, but I would just encourage you that if I, for example, if I got a call and somebody said, can I ask you a bunch of questions? I'd be happy to spend 15 minutes with them talking about, whatever questions they have. And so that's sort of my advice. I think I probably heard that in law school too, and maybe didn't listen to it, but I still think it helps to say it again.
Well, you've certainly been more than gracious with your time and knowing how busy the court has been. So we very much appreciate it. And I would just like to say as a parting shot that, you know, for law students and for young practitioners, if you're interested in federal practice, certainly look up the local chapter of the Federal Bar Association in the city of Richmond. You can, for law students, you can connect through your career development office, or you can find the Federal Bar Association online. And there's a lot of good programs and a lot of good opportunities for lawyers to get involved. And with that, Judge Haynes, I really appreciate your time. Thank you for your insight and your advice. And again, thank you for your time.
Well, you're very welcome. I really appreciated talking with you. And, you know, if anyone has any questions, they can feel free to ring me up and ask me. But, and I probably, JP, I'm glad you mentioned it because the Federal Bar Association was one of the organizations that helped implement the pro bono mediation program. And it's, you know, really through their involvement that we're able to have those pro bono attorneys. So, you know, I really think all the bar organizations in Richmond do such a good job. And certainly the Federal Bar Association is one of those. And it also provides a network for young attorneys to get into federal practice. So it's a good organization.